This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today, we're going to speak about what happens when a professional fraudster is convicted of a variety of fraud schemes, including insurance fraud, and then, of course, moves for acquittal in a new trial because they just can't believe they were arrested. But he's going to find that he must go directly to jail, do not pass go, and stay in jail. The defendant, Mr. Okeke, was charged with 2 counts, conspiracy to commit wire fraud and conspiracy to commit money laundering. He was convicted by a jury and moved the court for acquittal or a new trial in a case entitled United States v. Okeke, decided in the United States District Court for the Eastern District of Texas on August 21, 2024. The government charged that Okeke participated in a multitude of fraudulent schemes, unlawfully obtained money from their victims, including online romance schemes, business email compromise and investor fraud, healthcare and prescription fraud, and unemployed insurance fraud. Further, it charged that Okeke, along with others, did knowingly and willfully combine, conspire, confederate, and agree to commit wire fraud against the United States. Additionally, the second superseding indictment asserted that Okeke, along with others, not only coordinated how to receive money from victims, but also how to disguise, disperse, and launder that money once victims were defrauded. Okeke orally moved for judgment of acquittal after the United States rested. The court denied Okeke's oral motion. Following a 13-day jury trial, the jury returned its verdict and found Okeke guilty on both counts he was charged with. A Rule 29 motion for judgment of acquittal challenges the sufficiency of the evidence to convict, and that issue is whether, viewing the evidence in the light most favorable to the verdict, a rational finder of fact could have found the essential elements of the offense charged beyond a reasonable doubt. The fact finder, of course, is free to choose among reasonable constructions of the evidence, and it retains the sole authority to weigh any conflicting evidence and to evaluate the credibility of witnesses. With regard to the motion for new trial, the court may vacate any judgment and grant a new trial if the interest of justice so requires. Generally, motions for new trial are disfavored and must be reviewed with great caution. A new trial is proper only where the defendant's substantial rights have been harmed, either based on a single error or the cumulative effect of multiple errors. And although the United States introduced several bank accounts belonging to Okeke at trial, he claimed that no evidence was presented to the jury that any money from any victim entered his bank accounts, and further, Okeke asserted that no text messages or WhatsApp chats proved beyond a reasonable doubt that he had an agreement with his brother or anyone else to commit wire fraud. Additionally, Okeke contended that 2 witnesses and co-defendants for the United States testified that Okeke did not commit any illegal activity, and finally, Okeke stated that he testified in his own defense as a credible witness that he did not agree with anyone to commit the offense of wire fraud. Of course, the jury disbelieved him. The United States presented evidence regarding the discrepancy between Okeke's total net bank deposits and income reported to the Internal Revenue Service. The court found that the evidence presented was sufficient to support the guilty verdict. Okeke's motion argued that the evidence presented did not establish beyond a reasonable doubt a scheme to defraud and a specific intent to defraud, but viewing the evidence in the light most favorable to the verdict, as the court must, the court determined the jury could find Okeke guilty based on the evidence presented. The United States claimed that a new trial was not appropriate for several reasons. The United States claimed that it consistently and diligently provided discovery pursuant to its obligations, so that Okeke and his lawyers were totally familiar with the evidence to be presented. The court's denial of Okeke's motion for continuance did not warrant a new trial because Okeke has not shown that he experienced a specific and compelling or serious prejudice. A claim of prejudice to a party from the denial of a motion for continuance requires specific contentions and detail of that prejudice. And although Okeke claims that he experienced irreparable harm from his inability to formulate a defense, he has not identified any specific defensive measures he would have taken, so Okeke has not offered any specific contentions of prejudice from the court's denial of his motions. It was therefore ordered that the defendant's motion for acquittal and motion for new trial was denied. In my opinion, fraud perpetrators by definition have chutzpah, Yiddish for unmitigated gall, and cannot believe they were arrested, let alone taken to trial and verdict. The jury convicted him on all counts charged, and with the money obtained from his fraud, he hired lawyers who moved the court to set aside the verdict of the jury. Fraud, especially fraud hurting the elderly as well as insurers and other defendants, who were all harmed by his schemes, deserves a sentence that requires time in prison and restitution to the victims of his crimes. Hopefully, now that this motion is out of the way, the court will sentence Mr. Okeke to an appropriate stay in the federal prison. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you will be advised of every blog posting, usually 5, sometimes 6 a week. And you'll have access to the more than 4,850 blog postings. Please tell your friends and colleagues about the blog so that they too can subscribe to the blog and these videos. They're all free. And if you're interested in further detail about insurance, insurance law, insurance claims, and insurance fraud, please consider subscribing for a very small fee to my Substack publication. Thank you for your attention.